Okay, I'm Richard Elgar. I'm with the Foley Institute, and on behalf of the Institute, I'd like to welcome you all out here today. As you probably know, this is part of our semester-long series on the midterm elections, and I wanted to give you some advance notice of some of our forthcoming speakers. Next week, we'll have Washington's Attorney General, Bob Ferguson, coming to speak about some of the work his office has been doing. And the week after that, we'll have Paul Gronke from Reed College coming to talk about election laws and redistricting. And in that same week, our US Representative Cathy McMorris-Rogers will also be coming to speak. So I hope to see you at some of those events going forward. But today, however, I am pleased to welcome back to the Institute Alison Gash. It was about 7 years ago, wasn't it, you last here? Welcome back. Alison is Associate Professor at the University of Oregon, and her research focuses on the intersection of law and social policy with a specific interest in race, gender, sexuality, and disability in the context of housing and family. Her most recent book from this year is Democracy's Child, Young People and the Politics of Control, Leverage and Agency, which she co-authored with her colleague and also former speaker here at the Institute, Dan Tishner. That was published also by the University of Oxford Press. She authored in 2015, Below the Radar, How Silence Can Save Civil Rights, and I meant to say also the University of Oxford Press now because both of those books were so published. Alison has also written multiple academic articles on legal advocacy and collaborative governance, and her work has also appeared in Newsweek, the Chicago Tribune, Slate, and the LA Times, among many other outlets. And I'd want to point out that today I did receive a phone call from someone with public radio wanting to speak just out of the blue to an expert on abortion, and I just said, oh, it just so happens we have that person speaking here today. So she'll be speaking to them later on as well. She received her PhD from the University of California, Berkeley. So now please join me in welcoming Alison Gash.
First of all, it's really great to be back. Sadly, the last time I was here, it was all about Obergefell. And so today we're going to be touching on Obergefell, but not in the same sort of framework, in a slightly more plausibly depressed framework. So my apologies ahead of time if things are a little bit dire in the stuff that I'm talking about, but I think it's good for us to know sort of where we stand. And I should also say that, the stuff that I'm going to talk about today isn't about midterm elections specifically, but it is about, I think, a set of issues that are going to be somewhere on people's minds as they think about how they're going to vote. In particular, I think this year, especially in state elections, especially in my state. So I'm going to be talking about LGBTQ rights post-Dobbs, and obviously, the sort of big takeaway from Dobbs, the big focus of Dobbs was on reproductive choice, and so the issue of LGBTQ rights isn't, sort of obviously called out, at least not in the majority opinion. But there are a set of really important questions and really important considerations and likely really important implications that come out of both the language used in Dobbs, also the language used in one of the concurring opinions, but also the fact, right? The fact that the decision that was overturned in Dobbs, obviously Roe v. Wade, was a really critical gateway for pretty much all of the sorts of LGBTQ rights that we enjoy today. And so I'm going to sort of piece that apart so that we understand how Dobbs might affect LGBTQ rights in the future, and then also to give us sort of a sense of where we are right now in terms of potential attacks on the LGBTQ community, which are sort of at their highest moment right now. Things are pretty bleak. So when we're talking about the Constitution, right, because obviously when we're talking about Dobbs, we're talking about this question of constitutional rights. Essentially, the pathway to rights for groups like the LGBTQ community center on the 14th Amendment. So if we're looking at the 14th Amendment, we're looking at sort of two plausible pathways, right? One is through the Due Process Clause, which essentially says that everyone has a set of rights that can't be deprived without due process of law. So it doesn't say they can't be deprived of those rights, just says something about the fact that, right, if you're going to deprive people of those rights, they need to be, need to be done through some sense of due process. Now, over time, the Supreme Court has sort of altered that to mean essentially that there are a set of almost inviolable rights, right? Things that we would call fundamental rights. And so we'll talk about what that actually means in terms of the doctrine, right? But when we think about due process, we're thinking about rights. We're thinking about stuff, right? Stuff that can't be taken away from a person, no matter who that person is, right? There are a set of rights that exist. The other pathway that one could take is through equal protection. And so when we're talking about equal protection, it's essentially that we can't be deprived of equal protection under the law, and under court doctrine, there's a very specific idea that certain groups, certain kinds of ways of classifying individuals are especially problematic when we're talking about equal protection. And so when we're talking about equal protection, we're talking about groups and people, right? So one pathway deals with stuff that we can't lose, rights that we can't lose, and one thing talks about people, right, that can't be wrongly deprived of a set of protections, right? So stuff, people. And if it turns out that either your stuff has been deprived, right, your rights have been taken away, or you are a group who is now no longer able to claim equal protection under the law, basically what the state has to do is argue that there's a compelling interest, like a really important reason for them to take away your stuff, or engage in some sort of bias against your group. And even if they have a really, really, really important reason for doing the thing they're trying to do, they also have to argue and show that there's no other way for them to do it, right? That it is narrowly tailored to the specific issue, the specific goal that they have in mind. So it's really hard, right? It's really difficult. It's not impossible, but it is difficult for state policies, for any policy, to survive what is called strict scrutiny, right? This whole thing is called strict scrutiny. Now, if you are a group, right? If you are a group that has been traditionally maligned, right? Like the LGBTQ community, the pathway you really want to follow, right? The pathway you really, really want the courts to say you can access is equal protection, right? And specifically, right, there's a doctrine that essentially says if you are, if somebody uses a suspect classification, if you're a member of a group that has been traditionally and historically maligned, and if you are a member of a group whose sort of characteristics are immutable, right, that you can't change those characteristics, and you've been maligned because of those sets of characteristics, any sort of policy that uses that classification, any sort of policy that targets your group is going to be viewed through this lens of strict scrutiny, right? So when we think about policies involving racial classifications, when we think about policies involving religious classifications, those policies almost always are reviewed under this thing called strict scrutiny, right? Which means that the state has to sort of really, really argue that they have a compelling interest, right? And then it's narrowly tailored to that interest. So LGBTQ advocates for a while, for decades, tried to make the argument that when states use policies that target the LGBTQ community in some way, right? When they ban same-sex marriage, when they ban same-sex sexual intimacy, when they ban the word gay, right, in curriculum, that those policies should be reviewed under strict scrutiny because LGBTQ people are a maligned group, a politically unpopular group, a group, with immutable characteristics, right? Thinking about sexuality and gender identity, and thus, right, any sort of policy that targets that group in any sort of way should be reviewed under strict scrutiny, which would be great for those purposes because, again, super difficult to survive those challenges. But alas, the LGBTQ community has not been able to convince courts that any sort of policy reviewed or any sort of policy devised that targets LGBTQ folks should be reviewed under strict scrutiny. So instead, what the courts have decided to do is take a sort of case-by-case approach and review it under a fundamental rights framework, right? Meaning that if you're talking about same-sex marriage, right, and you're talking about bans on same-sex marriage, because marriage is a fundamental right connected to this idea of privacy, right, we can review a ban on same-sex marriage under strict scrutiny, right, because marriage is the fundamental right, but that doesn't mean that in the future, some other policy that targets LGBTQ folks would be reviewed under strict scrutiny, right? Because maybe the thing that's involved there is not a fundamental right. So essentially it leaves right, the gay community with one of the two possible pathways to constitutional protections, right? One of them. Now, of course, right, if you know about the Constitution and you know about various other elements of the Constitution, you know that there are actual other ways, right, that courts could have used to protect gay rights, but the courts in their infinite wisdom have really cut off a bunch of other pathways where minoritized groups could actually make claims. And so really most of the stuff sort of rests on this idea of the 14th Amendment. So we should also pause to know that there's also a set of constitutional challenges, right? So sort of the name of the game when you're talking about civil rights is you have to think about what does the Constitution provide in terms of advocacy for your group or for your particular cause. But then there's also what does the Constitution provide to your opponents, right? And for the LGBTQ community, the most potent source of constitutional backing for folks who oppose LGBTQ individuals, for the folks who are creating policies that would target, right, that would attack LGBTQ rights, is the First Amendment. And in particular, what we're talking about is free speech and free exercise, right? And so anytime that we're talking about a constitutional framework for LGBTQ rights, we're talking about a rights versus rights framework. We're talking about a situation where you've got free speech or free exercise rights on the one hand, right? And then this question about LGBTQ rights immersed in the 14th Amendment on the other hand, right? So you've got this battle of constitutional rights. So when we're talking about due process, right? When we're talking about due process, right? Because again, that's the only pathway that the LGBTQ community has. What we're really talking about is this thing called substantive due process. And this thing called substantive due process was essentially created around the 1800s through a series of court cases that actually dealt with laissez-faire economics. And essentially what the court argued is that immersed, at least like in the spirit of the due process clause, is this idea, right, that there are a set of fundamental rights that are so critical, so important to individuals, right, to the sort of state of our democracy, that they can't be overturned, right? They can't be overwhelmed unless, again, the state has a really, really important reason for doing so, right? So this was sort of referred to as substantive due process. And over time, one of the prominent subsets of rights that are ensconced in this idea of substantive due process is this idea of the right to privacy, right? We know that there's a lot of folks who say, you know, the right to privacy is not found in the Constitution, right? If you word search for the word privacy or right to privacy in the Constitution, you're not going to find it, right? But nevertheless, right, at least starting from 1920s and 1930s and a set of decisions dealing with schooling and then reaffirmed again in the 1950s and the 1960s through cases dealing with contraception and then later with abortion, this idea of a right to privacy became a really important location for a bunch of rights when we're talking about substantive fundamental rights. And so this idea of a right to privacy really gets solidified and nailed down in Roe v. Wade, right? So one of the important things to come out of Roe v. Wade, obviously, is this right to choose to have an abortion, but it's also this reaffirmation of this right to privacy. And what gets launched from Roe v. Wade isn't just, right, a sense that that folks can go out and choose to have an abortion during a certain time period, but also this idea that there is a right to privacy and that this right to privacy is connected to this idea of a right to intimate relationships and intimate decision-making and bodily autonomy, right? So this idea that we have this right to intimacy, a right to have private decisions made between people that are in our family, between ourselves and our physicians, this idea that we have this right to bodily autonomy, those are all connected directly to this idea that we have a right to privacy. So when you get rid of Roe v. Wade, the question is, what happens to the right to privacy, right? And so the big question for LGBTQ rights folks is, did Dobbs just undo Roe v. Wade with respect to abortion, right? Or did Dobbs undo Roe v. Wade with respect to the entirety of this idea of a right to privacy? Because if it gets rid of a right to privacy, then there's a big question for the two major decisions that deal with this question of bodily autonomy and intimate relationships in the context of gay rights, which is a case called Lawrence versus Texas, and of course, Obergefell versus Hodges, which I will talk about in a second. Now, how do we know, right? How do we know that it's plausible that the court might go after these kinds of decisions? Because if you read the majority opinion, the majority opinion does their best to sort of hem and haw around like the special case of abortion and the fact that really this is just going to be limited specifically to these questions of abortions because these other rights are so sacrosanct and so such a part of our democratic framework that we would never get rid of them, right? But we have this problematic concurring opinion that is written by Justice Thomas, right, where he specifically says that the court should reconsider, or that the justices should reconsider all of this court's substantive due process precedents, including Griswold, Lawrence, and Obergefell, right? And so he essentially calls out exactly the cases that he wants state actors, right? He wants Republican state actors to go after. And so we have to ask the question, right, of A, what is the possibility of these pillars, right, these pillars that are Lawrence and Obergefell falling, and what are the implications if they did? So to take this up sort of one at a time. So if we get rid of the right to privacy, right, we have these two sort of pillars of gay rights litigation that would be, right, could be vulnerable to reversal. The first is Obergefell versus Hodges. That deals with same-sex marriage. And the way in which the right to privacy works into that is by connecting this idea of this fundamental right to marriage, right, which is related to the sort of intimacy, choice of partner aspect of the right to privacy. And it's also related to the intimacy, bodily autonomy doctrine that's created through Lawrence versus Texas. Lawrence versus Texas deals with anti-sodomy laws, and that was a 2003 case. And essentially what Lawrence does is it gets rid of the hurdle that a lot of gay folks experienced, which was essentially that their relationships were de facto criminalized, right? So what Lawrence versus Texas did is it got rid of all the criminal statutes that remained that criminalized same-sex sodomy, right? And so once you get rid of a policy that criminalizes gay relationships, right, the doors open to the possibility of being able to provide affirming spaces for a whole host of gay rights issues, including being able to provide books about gay families in schools, including being able to provide support services for LGBTQ youth, right? There's a whole range of things that open up once you get rid of this sort of criminalizing, penalizing statutes and this penalizing language. Lawrence rests explicitly on Roe v. Wade. It is the primary holding that the case uses to lift up this idea of intimacy and bodily autonomy. If you get rid of Lawrence, right, then Obergefell is likely next. But although all eyes are on Obergefell, Lawrence is really the one that we want to be looking at. And of course, right, again, once you get rid of the right to privacy, once you plausibly place Obergefell and Lawrence in some sort of jeopardy, the only sort of equal protection argument that you can make, according to the court, is what's called rational basis, right? And here, what they argue is that if you're not part of a suspect classification, if you're not part of a group that's been traditionally maligned, if you're not part of a group with immutable characteristics, whose characteristics are being used as a source of bias, right, then essentially any policy that takes up your group, any policy that commits bias against your group in particular, is going to be reviewed on a rational basis, which basically just means as long as you're not calling out hate for the group itself, you can move forward, right? As long as there's a rationally related reason to some set of state functions, you can move forward with that policy. So Lawrence figures prominently in that calculus, because if a state can argue that there is something fundamentally wrong with same-sex relationships, right? In other words, if they can reinstate the criminal statutes that argue that engaging in same-sex sodomy, engaging in same-sex sexual intimacy is dangerous to your health, right? Is dangerous to the health and welfare and morality of your populace. If you can make an argument that it fits firmly within this idea of so-called state police powers, then you can escape this rational basis argument, right? You can survive this rational basis argument because, of course, all you would need to point to are a set of state policies that say that promoting gay rights is bad for the health and welfare of the population, right? So overturning Lawrence is really key in this sort of bigger agenda, right? In this bigger effort to be able to survive what is the remaining hurdle for the state, which is to survive equal protection. And then, of course, right, what has remained strong, and what is even, in fact, stronger now than it was even since 2015, are the court's commitments to free speech and the court's commitments to free exercise. We know that the folks that are enacting legislation that target LGBTQ folks, we know that the folks that are arguing most vehemently against a right to privacy, against Roe v. Wade, against Lawrence and Obergefell, are firmly supportive of an expansive conception of speech, an expansive conception of free exercise, and in particular, an expansive conception in how it deals with LGBTQ issues. Because, right, one of the ways in which folks deal with this issue is to say, my beliefs, right, my beliefs about the gay community are my beliefs, right, and I get to express those beliefs, and I get to preserve the right to not have to act against those beliefs in service of supporting public policy. And because they frame it as a belief issue and a religious issue, there's a ton of ways in which they sort of become exceptions to the rule, right? And so when LGBTQ folks lack constitutional backing, right, when they lack the scaffolding of the Constitution to fight against what is an even stronger scaffolding on the part of folks who oppose LGBTQ rights, it becomes really problematic. Now, it wouldn't be so dire, right, if there weren't much going on, right? If it were the case, as many people would like us to believe, that LGBTQ rights are fine, right? That public opinion polls, support gay people and trans people and gender fluid people. None of this would really matter, right? Because it only really matters if people pass policies that restrict these rights, right? So Thomas could call out the fact that he wants Obergefell and Lawrence overturned, but if nobody does anything about it, then too bad, so sad, right? It just ends up being an ugly decision in the dustbin of history. But the problem is, right, that we're in a moment of history where LGBTQ rights are really, really, really at risk. So immediately after Dobbs, and immediately in response to the concurring opinion that Thomas issues, Republican National Committee agendas actually reaffirm their original commitments against same-sex marriage. So we actually hadn't seen this for a while, but there were a bunch of state Republican parties who actually put back on the Republican agenda their opposition to same-sex marriage. There were also Republican policy makers who actually said, I would happily dust off my original anti-sodomy policy. In fact, Texas is the state that was the state involved in Lawrence versus Texas. They had never removed the policy from their books, despite the fact that it was ruled unconstitutional. So it's still there. So they don't need to pass it again. It's still there. So if they just start implementing it again, then they get to actually test it pretty quickly in terms of the court. So we already know there's movement afoot in that space. We already know that there's discrimination cases that the court is hearing, in fact, this term, right? Cases that deal with whether or not wedding service providers or any service providers are required to work with the LGBTQ community, if they've got some sort of religious or speech-oriented disdain for that community or those services, and those are sort of percolating their way up right now, and they're going to put into question cases like the Bostock decision, which was a case that was issued last year or the year before, that essentially said that gay rights and trans rights were protected under the Civil Rights Act, right? If you've got this sort of constitutional opt-out that is now likely going to be created, it won't really matter if you have statutory protections protecting gay people, because the Constitution will trump that. But we also, in a way more importantly, have don't say gay bills that are now percolating in states like Florida, in states like Arkansas, in counties, in school districts, right? We've got, on top of all the, critical race theory book bans, we have book bans on gay issues, on gay authors, on books that have, any sort of book that may have a gender fluid character or gender ambiguous character. There's a whole range of ways in which any sort of gay subject matter is being banned, right? Is being handcuffed in a really serious way. We have parental notification bills, right? Parental notification bills, not just about subject matter, but about the presence of gay students in a classroom. So there are some states that now require that teachers send home to the parents notice that there's a gay or lesbian student or a trans student or a gender questioning student or a gender fluid student or otherwise identified as queer student in the classroom, so that way the parents can make alternate arrangements so that their child doesn't have to be subjected in some way to the student, right? Which of course has a full range of privacy implications, because that would be outing the student in question, right? But if you don't have privacy anymore, it doesn't matter, right? Right. We also know that there's bans on trans athletes, right? These are percolating up in a bunch of states. I think 11 or 12 at this point have it. If Oregon's governor's race goes to the Republican, Oregon will also have one. So these are coming up, right? And they raise a whole range of equal protection and plausibly substantive due process claims. But then most important, or not most important, but in a way sort of most dire, are the bans on gender-affirming care, which sit squarely in this idea of a right to privacy, which sits squarely in this question, right, that was created, or this promise that was created by Roe v. Wade, which is all about your ability to be able to engage in a specific private discussion about your body, right, with your physician, and to be able to get the care that you so desire, because it's the right care for you. And so those bans on gender-affirming care are also percolating across the country. So again, not a happy talk, not happy information, but a set of real implications, a set of real questions that come out of Dobbs that don't have anything to do with reproductive choice, but have everything to do with the capacity for LGBTQ people, and especially LGBTQ young people, to be able to live with integrity and safety and in an affirming space. Thank you very much. Yeah.
Why wasn't the LGBTQ community established as a group under the equal protection for the strict scrutiny standard?
I mean, who wants to answer that? Who knows why, or who thinks they know why?
I just mean specifically.
There's a specifically vague answer to that question. Yeah.
Didn't it just apply to men, right?
No,
race.
It's a political answer, right? Which is that courts knew that it just wasn't politically palatable, right? Because they knew that if you did that, then a whole range of policies that are like the policies that are being implemented right now would fail. And they just weren't ready to say that either gays and lesbians had suffered traditions of exclusion, right? So they made a big, right, this is the gay agenda thing, right? So the gay agenda thing is a thing, right? Because it was a way for folks to say, hey, look, gays are really powerful, right? Look, they prevailed on same-sex marriage, right? They prevailed in getting a person elected to office, somewhere in California, right? And thus they have political power, thus they don't need this sort of extra protection. Then the other piece of it is born that way, right? So the reason why there's like so much attention paid to whether or not you are or are not born gay or born trans or born gender fluid or whatever is this connection to immutable characteristics, right? So if it is the case that you can't change how you are and are being, you know, and are the victim of bias because of something you can't change, then, right, you get the brass ring of strict scrutiny. But if it is the case, as folks who oppose gay rights would argue, that you're not born that way, that you can choose, that you can change, that all you have to do is go through conversion therapy and you're totally fine, right? Or if you're not subjected to stuff at school, if you have better parents, you end up, right? And of course, I'm being completely snide here, right? Then you end up fine, right? Then it's a choice, right? And because it's a choice, it's not an immutable characteristic, and thus you shouldn't get those protections. And so the courts have not been willing to delve into that fight more than a couple times, right? And the end result has been nope, right? We're not gonna give it, and no court now is gonna do it because we're in even a more conservative space right now than we were, right, 8-10 years ago when this was a possibility. Yeah, over here.
Yeah, why not abandon the 14th Amendment for queer people anyway, right? The 14th Amendment is getting recaptured by the right. It's going to take down affirmative action. It's going to take down ICWA.
Yeah, it's going to take out everything. Yeah.
Right? So why stick with it? Why not abandon it? Why not do something like the 9th Amendment?
Yeah.
The
Why
First Amendment,
not do the 9th?
right to associate,
Yeah.
right? Like,
No, this was the 9th is exactly what I'm talking about in terms of like the more obvious space to go, but there is zero precedent supporting the use of the 9th. Zero. None.
well,
Zero.
precedence is out the window at this point.
Yeah, but there's no court. So if a court isn't willing to entertain 14th Amendment protections, they're certainly not going to be willing to entertain 9th Amendment protections, right? So why not abandon it? Because there's no other path to go if you want to make a claim of a constitutional founding, right?
But why? Why not abandon the constitutional founding claim? Because it's...
So how else do you get rid of policies that are targeting gay people?
With policy, with Bostock, for instance, we have...
So Bostock makes a claim, right? So Bostock is another decision that was argued last year or the year before, and it basically says that, you know, the Civil Rights Act of 1964, which was amended later to include sex, right, essentially says it can't discriminate on the basis of sex. So Bostock argues, or essentially claims, that the word sex includes gender identity and sexual orientation. So thus, right, the Civil Rights Act of 1964 also then protects folks against discrimination on the basis of sexual orientation and gender identity because of the word sex, right? The big out is the First Amendment,
Yeah.
right? The big giant out, right, is the First Amendment. Now, you might argue, yeah, but not everyone can make, you know, a claim of religious beliefs, right? Not everyone, surely it's the case that not everyone can make a claim that they have a religious reason for opposing gay rights, except that there's this pesky decision called Hobby Lobby, right? And the Hobby Lobby decision makes an argument that if you are a closely held corporation, which incidentally, something like 92% of all businesses in this country sort of make the definition of a closely held corporation. So if you are a closely held corporation, you can actually have religious beliefs, which means you are subjected, or you can benefit from the big giant loophole, right, of the religious exception to the Civil Rights Act of 1964, right? So Bostock is fine, right? It's fine, except almost anyone can make a claim that they have an exemption. Almost anybody, right? And then when you add in free speech into all that, right, which everybody has free speech rights, sort of, right? Then it gets even murkier.
That's why I'm interested in the right to associate under the First Amendment. That is an interesting pathway that's never
It
been
is.
tried.
Yeah, it certainly is, right? And you know, again, the reason why privacy was so popular is because, right, part of privacy is that right to associate, right? Part of privacy is that right to choose who you want to hang out with and do whatever you want to do with whoever you want to hang out with, as long as it's not violating any sort of, you know, reasonable laws, et cetera, right? So that freedom to associate is like part of that space, right? So privacy bought you that, but now it might not, right? And so I suspect we will. I mean, we'll have to see different, more innovative, creative ways for LGBTQ activists and advocates to make a claim of constitutional protection. But the reality is that if courts aren't going to buy the stuff that they've been using, they're not going to pick up this new, shiny, untested doctrine either, right? Or not likely. They might, but not likely, right? So so there's a big question mark. There's a hand over here and then look over here. Yeah.
So you showed that quote from Clarence Thomas.
Yeah.
And it discussed like furthering the implications of overturning Roe.
Yeah.
So he's like one of the most originalist justices on the court. Do you think this is like kind of focused opinion on him, or the other conservative justices would pick up on it and then hurt the legitimacy of the court?
So do I think the justices will pick up on it? At least some of them will, right? At least some of them will. And if they don't, it would be weird, because all the stuff that they've been doing thus far, right, suggests a pathway forward. At the very least, to say, for instance, that because part of the Dobbs ruling is this whole like states have the right to do blah 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 blah, right, and we can't tell them not to do it. So at least part of it would be this sort of nod to state autonomy, right, which certainly this court in particular is like all in for state autonomy, all in so many interesting and plausibly frightening ways. Right, so I do think some of the justices would be compelled, right, under this idea that states should be able to make their own policies. Whether it takes down Lawrence or Obergefell, it's hard to say, right? Like, I'm not sure, right? But I don't think it's just Thomas, right? I do think that there's going to be some folks who are convinced. And then I also think there's going to be, right, other federal courts that are convinced to do some stuff, right, where the Supreme Court wouldn't review those decisions, right? So there's a whole sort of way in which it opens up the floodgates of plausible interpretations. And so we just don't know, right? Would it hurt the legitimacy of the court? The legitimacy of the court is already hurt. I mean, the legitimacy of the court is in shambles, right, frankly. And I just don't think it's an issue, right? It's an issue for some justices, but it's not an issue for other justices. And they would actually argue that the legitimacy of the court was already tarnished because of these super liberal Roe v. Wade type decisions, and that they're protecting the legitimacy of the court by going with originalism, right? So they don't see this as a hit to legitimacy. They see this as a returning to, a restrained, legitimate court. But that's a great question. Yeah.
I'm trying to understand. So kind of the challenge, the balance on these challenges that states are bringing is that the concept of privacy is not as firm or clear or established as the right to free speech. Is that?
Yeah. So there is no right to privacy.
Correctly?
Yeah, there is no right to privacy in the Constitution. The right to privacy was cobbled together through this idea of substantive due process. And was cobbled together initially through a set of like decisions that dealt with like parents' rights to choose the school of their choice, or teachers' rights to be able to teach students stuff that they wanted. It then sort of morphed into this idea of contraceptive choice, and then ultimately the reproductive choice.
So then these challenges that the states or the lawyers arguing the states' cases in that regard. Yeah. And this man, kind of asked, well, could you use another, amendment? And it sounds that just by precedent or tradition, you have all these challenges to the 14th privacy, and you've got this First Amendment standard. But it seems that it's just kind of a historical precedence then. Because it could be that you could use another pathway to do that.
You could. So precedence is a function of two things, right? It's a function of available language, right? So some authority, in this case the Constitution. So some plausible language in the Constitution that would point to some interpretation, right? And then the willingness of judges to accept that interpretation as a thing, right? Judges accept interpretations based on a number of factors, right? One of which is how they were trained, right? How they were trained as law school students, how they were trained as justices, right? The sorts of clerks that they might have. They are also compelled by the arguments made by attorneys that present their cases, right? The degree to which those interpretations are shared widely, right? So the reason why amicus briefs are important is because they show, like,
But it's
hey,
kind of culture,
right?
isn't it? I mean, it's a tradition in law school, you're taught that this, these are the amendments we should favor.
Well, it is,
this
but
what
so
the court-
let me just get to the third factor, right? And the third factor is precedent, right? The third factor is, right, not just that, we sort of have these preferences, but we have a sort of a scaffolding, right, of an institutional understanding of some stuff, right? So part of the reason why Dobbs is insane, right, is that it's the first time really in a long time, if ever, right, that the court knocked down firmly established precedent, right? Not just like precedent that was sort of like occasionally, right? It wasn't a dalliance with precedent, right? This is like the bread and butter of like most fundamental rights law that has existed since the 1950s. Like it's a big deal, right? So when you take out that giant chunk of history, right, that giant chunk of precedent, and you say it's no longer available or it's weakened in some way, right? Sure, could we go to the ninth? Yeah, right? There's nothing like stopping us in terms of like, it exists, right? But the other things aren't there, right? The justices willing to entertain that possibility, that's not there. There's no culture, right, of law school training around it. That's not there. There's zero precedent, right, supporting it. So if the court is willing to knock down firmly, historically rooted precedent, right, it's definitely likely not going to entertain the idea of this untested theory, right? So it's cultural, but it's cultural scaffolded by institutional doubling down over decades and decades and decades and decades and decades, right? Which now doesn't really matter, right? Yeah. Which also incidentally speaks to the irrelevance of precedent, which is a whole other speech to give about this. We'll go here and then here. Yeah.
Do you think that there's like maybe one judicial theory that we could ascribe the court to at the moment? For some reason, I keep being drawn to like a judicial activism. Their argument is to give states the right to decide. However, like you said, they are striking against past precedent, which we haven't seen before. Do you think that there's some kind of do you think it could be summed up to just judicial activism or judicial?
I mean, I have colorful language that I would like to use to describe it. But I mean, it's to say that it's activist doesn't even capture the craziness of it. I mean, it's almost like. I don't know. I mean, Mike, what do you think? Like, I'm trying to think of like what word. It's like renegade.
I mean, I
or
have colorful language as well.
Yeah, I know.
It's ideologically motivated, is what I would say.
Yeah, I mean, I guess that it would be sort of judicial, like ideological pandering. I don't know. I mean, and pandering is a problematic word too, but it is vastly more. It's an ideologically driven originalism, right? That is scaffolding all like their understanding of the court because it's not just originalism, right? Because Justice Brown gave this wonderful, right, schooled them on what an originalist version of an understanding of the Constitution would be if in fact we were being originalist, but we're not being originalist because we're like cordoning off whole sections of the Constitution as like exceptions to the rule of originalism. So it's not originalism, right? It's ideologically motivated, right? Originalism or ideologically blinded originalism or something, right? because it's not, it is for a very specific purpose and towards a very specific understanding of the document and the founding fathers, right? I mean, the same folks that are making these arguments are also making an argument that there is no separation of church and state, despite the fact that we have letters, actual letters, right? Which we don't always have, but actual letters that say the word separation of church and state, right? So that's sort of where we are, right? I think there was a hand over here.
Thank you.
Over here. Yeah.
Well, to that question's point, right? We have had some success in state constitutions, but what do you think about? Oh shoot! What was I gonna say? So Alito differentiates, right, abortion from the others by saying the state has a compelling interest in the fetal personhood.
Right.
How much stock do you put into that as a barrier to kind of the right to privacy, other right to privacies? Because Roberts isn't on board with that. Kavanaugh probably isn't on board with Thomas.
Yeah. I
So,
mean,
not that I want to put my faith in Brett Kavanaugh.
yeah.
But
No, I know. Strange bedfellows. That's where we are right now. So you could make an argument that there is something special about reproductive choice. But I would argue that you could make an argument also about the other sorts of policies that are implicated in privacy that are also available for state intervention, right? So if you're going to make an argument about fetal personhood, why couldn't you make an argument about children's welfare or parental rights, right? And if it were the case that the same folks that are sort of driving the ship for these arguments weren't also making those other sorts of claims, then maybe sure. But the same legal institutes that are making the arguments that were used in Dobbs are also making those same exact arguments in the context of LGBTQ rights, right? So will there be other forms of privacy that are protected? Yeah, probably, right? But I don't know that the forms of privacy that will be protected will include these things, right? I think we're going to see another sort of case by case selection of like which things are or are not privacy, which is also hilarious because the reason why, right, conservatives say the right to privacy is problematic is that it puts too much authority in the hands of the court to figure out what is or isn't privacy. But now we're exactly in that space, right? But a sort of backwards, right, deconstructed privacy, essentially. Yeah.
So we've been talking about like the court a lot, and it's made me wonder, like, right now the current court is pretty they have a pretty extreme ideology of what's going on, and it kind of seems like that's probably going to continue. And right now we have like a pretty young court, and it just like, with the path that the court's going on, and then looking at like Congress and how like legislatively, like I was seeing how like they could have done something about codifying Roe, but they didn't, and they could do stuff about codifying LGBTQ rights, but they're not. And it seems like party polarization is a big issue. So what can like the average American who might not be like politically, I guess, like super knowledgeable about what's going on do? Because it kind of just seems like it's frustrating, because if you vote for people, they're not going to codify your rights, and then the people you vote for are going to put other people in place for lifetime appointments, and they're just going to have these crazy, opinions and ideologies. So what can they do?
Yeah. Well, so that's a great question. So I would say, first, states are where the action is, right? So none of these decisions say that you have to ban abortion or ban LGBTQ rights. It only says that you can, right? So if you're in a state that doesn't, and you are, then if you care about these issues and you want to keep reproductive choice and you want to keep LGBTQ rights, vote for people that care about those things, right? If you don't want reproductive choice and you don't care about LGBTQ people, vote for people that also don't like those things, right? But states are where it's at. even local government is where it's at, right? So even if you are in a state that doesn't like those things, there's a lot of authority and space for local government to make things far more palatable than would otherwise be the case if the local government weren't supportive. But I would also say that, like the work that I'm doing right now is really about mutual aid organizations and, sort of private spaces of reform and advocacy, right? Nonprofit organizations, all those sorts of things. Because, I came of age, like my colleagues came of age in a moment where the state was sort of centered in this space of like, what do? We litigate, or we call our state representatives and make them change a policy, or we have a ballot initiative. But it wasn't always that way, right? It used to be, that you wouldn't go to the state. And in lots of other areas of the world, you don't go to the state, right? You do things despite the state. And so there's a range of things you can do to support communities and issues that you care about, right? That are not about the state, right? That are about doing stuff on your own, right? Creating organizations, joining mutual aid organizations, joining nonprofits, volunteering for places, right? Creating spaces, right? And that's certainly something that you still can do, even when you've got these really, sort of quasi-authoritarian state regimes. Yeah.
I'm kind of following up on that. So at the federal level, it's true, the feds have declined to codify Roe v. Wade and declined to do all these other rights. But in other areas like the Voting Rights Act, right, they have done that, and then the Supreme Court strikes it down.
Mm-hmm. So
even if Congress were to codify these things, what do you think the fate would be going to the Supreme Court?
Yeah, so Dobbs really takes a very specific understanding of states' rights, right? So it's plausible that even if Congress were to codify some version of support for abortion, abortion care, depending on how it was written, it still might fly in the face of Dobbs, right? So it would have to be written in such a way that it escapes the various landmines that Dobbs created, right? So I do think that given the court, right? The federal government, federal support is great, right? But federal support always comes with giant caverns of caveats, right? Giant. State support, in a way, is not better, but just as important. And so even if you have federal support, getting your state policymakers to double down on some really precise language, so like ballot initiatives, right? What folks who support reproductive choice are doing right now is they're going to every state that supports reproductive choice in the polls, and they're trying to get folks to vote on constitutional amendments to the state constitutions that say we support abortion, right? Because in states that are passing these bans, there's still possibly popular support for reproductive choice, right? And so so you're going to see folks taking advantage of different configurations of political advocacy that aren't just at the federal level. And that would withstand, because if you did that, it still would be fine under Dobbs, because Dobbs is just the state. Until they come up with a new doctrine. Which they will. One more? Or no?
Let me ask a quick question now, if I can.
Okay.
I know we said we weren't really going to talk about the midterm elections and wasn't really part of that series, but we've seen there's a bit of a backlash in terms of the Dobbs decision straight away, but I wonder if you could talk a little bit about that, and also whether there might be any kind of backlash around gay and trans rights as well, or if you think that's going to be more below the surface.
So, I do think we are going to continue to see a backlash to Dobbs. It's the reason why so many, Republican candidates, sort of erased their anti-choice positions on their websites, right? That they're trying to say oh, it's actually not that important to us anymore. Now we're verging into, other territory. Whether it is enough of a backlash to override partisan commitments and other issues is a question, right? So everybody was incensed right after Dobbs, but November is like 5 years away, right? And unless people are incensed about reproductive choice 2 days before the election, it might not matter. It might, but it might not, right? So the economy is definitely going to be present on everyone's mind. And so the question is, like, will the economy override people's sort of abstract concerns about reproductive choice? Maybe, right? I know in Oregon, right, affordable housing and houselessness are like way on the top of everyone's minds. So much so that they are willing to entertain the possibility of two anti-choice candidates, or one sort of anti-choice and one super anti-choice candidate, coming in and driving the ship, right? In part because they feel that the sort of reproductive choice stuff is already safe, right, in the state. So it really sort of just depends on like the constellation of like things that are on the top of people's lists at the moment, right? And I just don't see reproductive choice being on the top of lots of people's lists. Some, but not on everyone's. And then I don't think LGBTQ rights is on the top of anyone's list, except for like people like me who are like focused and committed and care because of, various reasons. In fact, the reason why Republicans are doubling down on LGBTQ rights and shifting away from abortion just a scooch is because it's a really great way to appeal to the base, right? It's a really great way to appeal to your like super, passionate, committed, anti-choice base without having to say the abortion word, right? That's always been why Republicans have gotten involved in the LGBTQ stuff, because they very quickly realized in the late 80s that it was a really nice substitute, right? It got you the same folks, but with a little less of the trouble, because it was a little less inflammatory to say that you were against gay people than it was to say that you were against reproductive choice. And that's what we're finding, right? So the reason why people are having a ball creating these bans is that there just isn't that much hubbub about it right now, unfortunately.
Well, unfortunately, we are now out of time.
Yep.
So thank you very much to all of you for coming out.